Okay, so before we start talking about Davis-Bacon, I wanted to provide a quick overview of Nebraska Business Development Center and our PTAC program services for those who might not be familiar. So NBDC provides a wide range of services statewide, including business planning, business valuation and loan packaging, marketing strategy reports, government contracting assistance, export business planning, technology commercialization assistance, and exit and succession planning. The program that I work with is the PTAC program, which stands for Procurement Technical Assistance Center, and we provide government contracting assistance. I do regularly refer clients over to other NBDC programs if they could also benefit from those program services as well. The great news is PTAC program services are free of charge to Nebraska-based businesses. Yes, I did say that NBDC does provide statewide services. We have small business development centers throughout the state to provide some of the services that we just mentioned. Other services like our export business planning and technology commercialization are provided from NBDC's main office at the University of Nebraska at Omaha campus. Our PTAC program services are provided by 5 PTAC consultants and support staff. I have 2 colleagues who serve the Omaha metro areas as PTAC consultants. Another colleague of mine offices at Southeast Community College in Lincoln, and he serves Southeast Nebraska. Another colleague of mine offices at Norfolk Chamber of Commerce, and she serves Northeast Nebraska. I serve much of central and western Nebraska from the University of Nebraska at Kearney, here in Kearney. And you can see from the map on the slide, that kind of designates each of those areas or territories. So if you are located in one of those counties, that kind of indicates which office you would work with. For those on the webinar that I haven't had the pleasure of meeting before, I wanted to provide my contact information. And you will find my contact information also in the chat box. So what exactly does a PTAC program do? We serve as a resource to companies that are interested in doing business with government agencies. There are a wide range of services that we can assist with. One of the more common requests that we receive is assistance with the System for Award Management, also known as SAM, registrations. The SAM registration is required for businesses that are pursuing opportunities with federal agencies. We also provide free access to bid match services, market research, and events like today's webinar, as well as other value-added events like our Agency Spotlight Series and Meet the Buyers Conference. Those events give businesses a chance to meet agency procurement professionals. We're going to share a link to NBDC's upcoming events in the chat box as well. So if you would like to check out those events, go ahead and use that link. So you might be thinking, that's great, but what kind of business services or what kind of businesses do the PTAC program provide assistance with? So each year NBDC honors a government contractor of the year who has shown a commitment to and excellence in government contracting. By highlighting a few of those award winners, I'm hoping to illustrate the range of companies that we serve and some insight into the assistance that we provide. For instance, Cashway Distributing, who is a food service distributor, was NBDC's 2017 Government Contractor of the Year. The types of assistance NBDC provided are highlighted in yellow text on each of the slides. Our 2018 NBDC Contractor of the Year, Government Contractor of the Year was McDaniel Farms, and they provide prescriptive goat grazing and hay to federal agencies. Our 2020 Government Contractor of the Year is Turtle Creek Construction, who has expanded their offerings to include products and other services in addition to construction. So you can see there isn't just one type of business that we serve. We do serve a wide range of businesses and provide a wide range of services to those companies. Since I've mentioned what the PTAC program does, I think it's also important to identify what we don't do. We are not attorneys. We are also not CPAs. So we're not able to provide legal or financial advice. We're also not able to market on behalf of our clients. As mentioned earlier, my best explanation would be that we are a resource to Nebraska businesses. So with that overview of NBDC and PTAC program services, let's go ahead and talk about Davis-Bacon Act. With Davis-Bacon Act, we're going to provide some information today to answer some basic questions like why, what, and how when it comes to Davis-Bacon Act. I'll provide some resources during the presentation, and if I don't answer questions that you might have during today's presentation, please feel free to reach out to your local PTAC consultant for additional assistance. Before we start talking about Davis-Bacon, I like to take a quick poll. So in the chat, please share your feelings or perceptions about Davis-Bacon Act. Just go ahead and type in 1 to 2 sentences to kind of reflect your feelings. We like to keep a family-friendly setting, so please keep any comments rated G for general audience. But again, we kind of want to find out what your experience or what your feelings are with Davis-Bacon. So yeah, Daniel, and would you be able to read some of those comments then, Daniel, if they're in the questions and answers?
Yeah, so we have some coming in. Thank you for typing those in, everybody. So we've got, sometimes it's hard to fill out the forms. Good for contractors, so they aren't taking advantage of. Lots of paperwork though. Let's see, most contracts we are seeing are under SCA, not Davis-Bacon. Need easier forms. Yeah, a lot of questions about forms and the paperwork. Not as confident as I like to be with Davis-Bacon. Good for employers to understand their role and responsibilities to employees. Yeah, thank you everybody for typing those in the chat.
Absolutely. Great comments. Those are some that I do hear. You know, it's great to hear some positive comments. When I first started, it seemed like there were a lot of negative feelings about Davis-Bacon Act, and I think that it was because some of the contractors that I was working with didn't fully understand, or maybe hadn't been exposed to Davis-Bacon Act. Sometimes their perceptions were based on somebody else's feelings about Davis-Bacon Act, and that's kind of why I like to get that kind of established. You know, how do you feel, and what leads to those feelings? So that's great feedback or great comments that we've gotten there. So let's talk about the why and the what, and a few of the comments did talk about this. So Davis-Bacon Act was adopted in 1931 to establish a requirement for companies to pay prevailing wages on any public works projects. The reason Davis-Bacon Act was enacted was to provide protections to local contractors, and that was, I know that at least one of those comments had mentioned that. So it does provide protections to local contractors from what was seen as unfair pricing from outside companies that were coming in to bid on government projects. So again, labor laws are different today than they were back in 1931 when Davis-Bacon Act was enacted. I think that Kansas may have actually had one of the earliest predecessors to Davis-Bacon Act. They enacted legislation in 1891 with a law requiring local rates. So again, I'm not sure if this explanation really impacts how you might feel about Davis-Bacon, but I think it is helpful to know the reason behind Davis-Bacon Act if you're starting to work with that legislation. So some of the feelings associated with Davis-Bacon Act in the past that I experienced probably related to some of the requirements. So we're going to take a look at those. In general, Davis-Bacon Act requires contractors and subcontractors to pay prevailing wage rates and to maintain and submit payroll on a weekly basis. The prevailing wage rates are established by the Secretary of Labor for various labor categories. This can be a bit of an adjustment for companies that don't pay on a weekly basis or who may not normally pay the prevailing wage rates to their employees. When I first started as a PTAC consultant, I would often hear that concern much more than I have in recent years. And I'm not sure if that's because labor shortages have kind of changed the wage rates. But I used to hear pretty frequently that business owners did not typically pay their employees prevailing wage rates on non-federal projects. As I mentioned, the last couple of years, most companies that I've talked to about Davis-Bacon Act indicate that they do normally meet or potentially exceed the prevailing wage rates. So again, the labor shortage has definitely impacted what contractors pay for employees' wage rates. Just to clarify, the prevailing wage rate is a minimum wage rate. So it is not a maximum wage rate. You can certainly pay more than what Davis-Bacon Act prescribes. So why do you think Davis-Bacon Act requires contractors to maintain and submit certified payroll records on a weekly basis? If you could just type into the questions and answers really quick, maybe your thoughts on why it requires contractors to pay and report on a weekly basis.
Sure, yeah. To hold us accountable, compliance, to ensure the employees are being paid the correct wages.
Yeah, and those are all exactly right to some degree. It is a compliance thing. It is holding contractors accountable. It is ensuring that the employees are being paid the prescribed rates. So weekly payroll does provide safety mechanisms for workers, but it also provides safety mechanisms for employers or for the contractors. Some beginning contractors that pursue their first federally funded work, I've worked with some individuals that jump right into a federal project, and sometimes they struggle with that initially. I've also worked with some contractors that have worked with community development block grant projects. And some of those community development block grant projects allow the contractors to work with CDBG administrators who might be more familiar with Davis-Bacon Act. Because they work with contractors on an ongoing basis for federally funded projects, sometimes they can help provide some insight. So again, not all CDBG administrators provide the same level of service. However, some of the CDBG administrators that I'm familiar with do work with new contractors to ensure that they understand and are completing that weekly payroll both on time and correctly. By doing so, it can really help contractors avoid spreading out some potentially costly mistakes over a longer period of time. So by doing it on a weekly basis, if there's going to be some issues or some mistakes, hopefully they can get that resolved and taken care of before it extends out to a longer time period. So what happens if you don't follow the rules? There are several potential penalties for non-compliance. The government can withhold contract payments to cover unpaid or underpaid wages. The government can also terminate your contract and hold you liable for any excess costs. That seems pretty excessive, but as you can see, there's some additional potential penalties. The government can pursue treble damages under the False Claims Act. The civil penalties from the False Claims Act and those treble damages could be 3 times the dollar amount of the contract. So that's pretty significant. The government can also debar your company from federal contracts for at least 3 years. And you may be responsible for liquidated damages under the Fair Labor Standards Act. You could also potentially face criminal charges for falsification of documentation. So as you can see, there's a lot of reasons to make sure that you're meeting the requirements of Davis-Bacon Act. There are obviously several requirements with Davis-Bacon Act that must be followed, and there are some important requirements to be aware of. First, Davis-Bacon Act applies to federal projects in excess of $2,000. That seems like a pretty low dollar threshold, from my estimation anyway, to be required Davis-Bacon Act. However, that's the amount that's set by regulation. So both contractors and subcontractors are responsible for providing the prevailing wage and fringe set by Department of Labor for that location and time period covered. Again, any federal projects in excess of 2,000. When I say any, there are a couple of exceptions. One is regarding housing. So again, it's not all housing projects, but there are some that are exempt from Davis-Bacon Act. So you want to make sure that you're aware of what is required and what's not. Secondly, any contracts in excess of 100,000 require both contractors and subcontractors to pay time and a half for all hours worked over 40 hours a week. And again, the payroll is weekly, so that's how overtime hours would be determined. It's again protecting against situations where a contractor might average over a 2-week period or a month period. It is in fact weekly, determined on a weekly basis. Third, again, both contractors and subcontractors must post Davis-Bacon Act employee rights poster, the WH-1321, in a prominent and accessible location at the worksite. We're going to go ahead and post a link in the chat that will take you to the Department of Labor website for the WH-1321. That poster must be on 11 by 17 paper or taped and pasted together to form 11 inches by 17 inches. So again, it has to meet that size requirement and it has to be in a prominent and accessible location. Employers must also maintain payroll and basic records for all workers during the course of work and for 3 years after. So contractors and subcontractors must make those records available to the Department of Labor for inspection, copying, or transcription. And if you don't make those records available, the government may suspend payment and take further action that we discussed previously. So obviously it's best to make sure that you're meeting those compliance requirements. Most solicitations I've seen that are subject to Davis-Bacon Act will include a prevailing wage rates chart for the location and time period specified. However, it's not a bad idea to make sure that you know where those wage rates are posted so that you can periodically check to see if there's been any adjustments. There are other related acts, including the Copeland Anti-Kickback Act, that prohibits employers from inducing employees to forego compensation that they're entitled to. We're going to post a link in the chat again to the Laws, Executive Orders, and Regulations website for Davis-Bacon and related acts. So Davis-Bacon and related acts prevail regardless of any alleged contractual requirements or relationships. In other words, contractors aren't able to avoid meeting those requirements of Davis-Bacon Act by indicating that there were previous employer-employee types of agreements that would allow the contractor to avoid Davis-Bacon Act requirements. Contractors are also responsible for making sure that they follow any other applicable employment or labor laws that are required. Those are things like E-Verify, again, the Fair Labor Standards Act, Family and Medical Leave Act, those types of requirements. So again, you want to make sure that you're aware of any employment laws that are required. So I mentioned being able to identify where the wage determinations are found. Previously, Department of Labor had a website that housed all of those wage determinations. Those wage determinations are now located at betasam.gov. So we're going to post a link to betasam.gov in the chat as well. You can see on this slide the selections for wage determinations. You'll also be able to select Learn About Wage Determinations, which has some great resources, or Search Wage Determinations. If you select Search Wage Determinations, you will then be able to select Davis-Bacon Act and the wage determination type. You'll be able to enter the state and county to find the appropriate wage determinations. And as indicated, again, you want to make sure you select the correct construction type when selecting the wage determination. Wage determinations will provide critical information that you need to consider when bidding a federal construction contract. Make sure that you read and understand all relevant information. You don't want to just look up the wage rate and fringe. You want to make sure that you review general information at the beginning of the document, as well as the information notes that follow the wage rate and fringe, if applicable. So you can see here kind of a sample for Adams County, Nebraska. And again, talks about the building construction projects, the type, and has some important notes about wage rates and wage determinations there. This next slide includes some notes. So in addition to the wage rates and fringe that are shown, the additional requirements might include vacation, sick leave, paid holidays, those types of things that again can impact the costs associated. If you're bidding on a Davis-Bacon and those are required, again, you want to make sure that you calculate those costs in because you are responsible for those expenses. Contractors and subcontractors must pay affected employees on a weekly basis, as we mentioned, and provide the contracting agency with a copy of all payrolls on a weekly basis. This reporting must be completed within 7 days after the regular pay date. As indicated on this slide, contractors can use the Department of Labor Form WH-347. That is a great resource to contractors, especially if you're not as familiar with Davis-Bacon Act. Contractors can, however, use any other form as long as it includes all required payroll information and uses identical wording contained in the Statement of Compliance. And we're going to show an example or show the WH-347 here in just a moment. That includes the Statement of Compliance. And so again, that's important to use. And you'll see a link to the form WH-347 there in the chat box. So here's a look at the Department of Labor's form WH-347. As mentioned, the form is optional. However, it does ensure that you're meeting payroll requirements under Davis-Bacon Act. On page 1, contractors will enter company information and payroll information. On the second page of the form WH-347, employers complete the Statement of Compliance and indicate how fringe benefits are to be accounted for. We'll talk a little bit more in the next few slides how employers can account for fringe benefits if they do not provide a fringe benefit plan. When Department of Labor completes an investigation, it's important to understand that the first person that the Department of Labor interviews is the person who signed the payroll. So you want to make sure that the person who's signing the payroll is able to identify who performed the work, the classification of each one of those workers, and the wages paid according to the applicable wage determination. The weekly payroll has to be submitted to either the federal agency, if it's a party to the contract, or the applicant, sponsor, or owner for transmission to the federal agency. And that's in the case that the federal agency is not a party to the contract. Again, the WH-347 is optional for use. Just make sure that if you're using a different form, you include all required payroll information and identical wording contained in the statement of compliance. We're going to put that wording from the statement of compliance in the chat box as well. Again, make sure that you're aware of falsification of any of the above information when you're filling out a WH-347 or a separate form, that it can be prosecuted. So again, these are really important things to be aware of, and that the person who's signing is making sure that all information is correct. So if you don't currently offer fringe benefits, you might be wondering what your options are. Contractors obviously pay base wage rate through payroll, and they choose how to meet the fringe requirement. So let's take a look at an example using $35 as a base wage and $18 in fringe benefit. Again, we would have found this from the wage determination. So adding those two numbers will total $53, but of course there are other things to take into consideration. So the fringe benefit obligation can be met through things like health insurance, retirement plans, and pensions. And this 29 CFR does lay out the requirements of meeting that fringe. Some contractors who don't offer fringe benefits choose to pay all or some of the mandatory fringe benefit as wages. They see it as the easiest way to satisfy Department of Labor compliance. And that may be the best solution for some contractors. However, companies that choose to pursue federal contracts on a regular basis might want to consider the impact of paying fringe benefit as wages. Obviously, all cash wages are subject to payroll burden, which increases labor costs. For our example, we're going to use 25% of average payroll burden, although these rates obviously can vary by company and by state. For our example, we're indicating that Company A is choosing to pay the fringe benefit rather than providing bona fide benefits. Company B, however, is providing a bona fide fringe benefit plan. So the payroll burden is obviously less for Company B in this example. It reduces the hourly cost, as you can see, by $4.50 an hour per employee. So that doesn't always determine whether or not you receive a contract, but it can definitely impact your bid, especially if you have a good number of employees that are going to be working on a federal project. Offering bona fide fringe benefits is a business decision, and companies should make the best decision that is right for them. So what makes fringe benefit plans bona fide? It has to be in writing, and it has to be communicated to covered employees. It also has to have irrevocable contributions. It has to be a group benefit plan, and contributions must be made to a third party or a trust. Also, it must be conveyed, or it must convey a benefit to the person actually performing the work. And it has to be accounted for on an hourly basis when reporting weekly payroll on the Department of Labor Form WH-347. So in other words, even if you provide a bona fide benefit plan, if you don't report that on an hourly basis on the WH-347, you cannot necessarily count that. So you want to make sure you fill out that form correctly, especially if you do offer bona fide benefits. So we're going to add a few more resources in the chat box. Again, these are great Davis-Bacon resource links. The websites are all provided by Department of Labor. And the first is a link to the main page for Davis-Bacon and related acts. So we'll post that into the chat box. The second link is a Department of Labor web page that provides resources for employers, including regulatory library, e-laws advisors, forms, compliance toolkits, and other resources. We've got that in the web or the chat box as well. And the third link provides a list of prevailing wage seminars that may be helpful when implementing Davis-Bacon Act. So that has some presentations that we're going to share as well. I hope that this information was helpful, and we appreciate you attending today's webinar. If you have any questions, we'll go ahead and field those at this time.
Awesome, thank you, Chuck. As Chuck mentioned, we can take questions now, so feel free to type your questions in the question box. We have one so far, so we'll get started here. Question is, where can I find what the exceptions are for federal housing projects and Davis-Bacon, as you mentioned earlier?
Yep. So again, usually that's going to be outlined in the contract. So that's a great question. I know that local housing agencies will oftentimes have federally funded projects, and they will identify whether that project is subject to Davis-Bacon Act or not. My understanding is if it's housing specific, it is exempt from Davis-Bacon Act. So that would be things like replacing windows or putting on siding, replacing doors, insulating, when it comes to those housing projects. However, things like replacing sidewalks or parking lot work, when it comes to a housing project, would not be exempt. So those would be, in fact, subject to Davis-Bacon Act. So like sidewalks, parking, those types of things, if it is not housing specific. Great question.
Next question is, how would you include Davis-Bacon in your capability statement?
So when it relates to a capability statement, I think that there are some things that federal agencies want to know that you have experience with or are able to provide. So obviously, you want to have capabilities within the industry. So proven capabilities, past performance is important. Davis-Bacon Act experience is good to also identify. So again, if you have Davis-Bacon Act experience, I think mentioning that in a capability statement is good. And also your bonding level or your ability to receive bonding is the other thing. So those are some things that federal agencies, I think, do want to see from contractors. So again, if you don't have that experience, you may consider subcontracting or working with community development block grants to get some of that experience and kind of dip your toes a little bit before jumping right into a large federal project anyway. Again, great question.
This one is, in what ways does Davis-Bacon relate to independent contractors as opposed to employees?
Yep, that's a great question as well. So again, there are some exemptions. However, again, there's this caveat. You want to make sure that you're aware of those exemptions and the different impacts from the types of work that you do. So in general, independent contractors, let's say the owner of the business, is typically exempt from Davis-Bacon Act. Now, again, I say typically because there are exceptions to that exemption. I do believe that if you're performing work in multiple states, then that exemption does not apply. So again, you want to really kind of take a look at the Davis-Bacon Act, and I'm going to repost the website link if I can find it here. And I think the construction laws, I'm going to post that in the chat. I believe that that will provide some overview of some of the exemptions and any exceptions to those exemptions, because again, it's a little bit more complex than saying this applies 100% of the time or it doesn't. There definitely are some exemptions, and there's exceptions to those exemptions. You want to make sure that you're following the regulations. If you have specific questions, I would say that, again, the Federal Department of Labor's office would be the location that you would want to visit with and make sure that you get answers to your questions.
All right, our next question is, what are the most common errors you find on certified payroll reports?
You know, again, I don't necessarily review those myself, but I would say that oftentimes, especially I've seen this in the past with companies that have not worked on federally funded projects. They may not be familiar with Davis-Bacon at all. And even if the wage determination is attached to a contract, I've heard of contractors not reviewing that information. And so they may or may not pay the prevailing wage rate or meet the fringe benefit requirement. So that's kind of one of the first things is, again, any contract clauses or attachments, you want to make sure that you do read and understand those. You don't want to make assumptions. And so making sure that you have the correct prevailing wage rate, that you're meeting the fringe benefit requirement, and then also any of those additional requirements like vacation, overtime, those types of benefits that are required in addition to the prevailing wage rate, you want to make sure that you do provide those as required as well. The form itself, you know, I know one of the comments was the form can be kind of confusing. It can. So if you have specific questions on the form, definitely feel free to reach out. But overall, you know, I think if you meet those requirements and you're reporting them, you know, you definitely, that's probably, you know, 9/10 of the law, I would say. Kind of that old adage. You know, it doesn't mean that you can get a free pass on filling out the form, but you definitely want to make sure that you're meeting all of the requirements.
All right, our next question here is, do you know the last time a survey has been done in Nebraska for wage determinations? Is one planned?
That is a great question. I was actually just, the example that we used, let me try to pull up that wage survey here quick. I'll go back to the page. So 2021 is when it's dated, January 22nd, 2021. Now, I don't know if that was specific to a survey. I would guess that it was. I don't know if those relate directly to surveys. That's a great question. I would have to reach out and try to find that answer. If you want to, Daniel, if the individual that posed that question, if you want to forward that question to me, I'll get back to them. Yep.
Yep, absolutely. All right. What if you have independent contractors working on projects?
Yep. So again, the independent independent contractor may or may not be exempt from Davis-Bacon Act. Again, you want to make sure if you're going to try to use an exemption, make sure that the exemption does apply. As indicated previously, when I first started as a PTAC consultant, I would oftentimes hear that an employer may not pay the prevailing wage rate that was required normally. I don't hear that too often anymore. And again, I think that that's partially because of the shortage of employees and contractors adjusting their wage rates, to be honest. So I don't hear that too often anymore, and I would assume that most independent contractors are going to be paying themselves, the prevailing wage rate. However, again, if you're going to try to use an exemption, make sure that you do meet the requirements of that exemption. I think that answers the question, or hopefully does. If you have specific questions, you can definitely reach out to me.
Let's see. I don't know if this is a question, maybe just a comment to respond to, but errors I find is listing a classification not shown on wage decision.
Okay, that's a good point. So when contractors look at those wage determinations, that is a comment that I have had in the past. It doesn't, there is no specific category for an employee potentially on a project. So it doesn't really meet those categories that are listed. So you can request a survey, but so yeah, that's a great question. I think that what most companies probably do is they try to use something that's most closely related. Again, that is not always as simple as it seems. There are some specific requirements with regards to those categories. So again, I would say or suggest that you request a survey if that category is not outlined. And if you're going to try to use a category, again, that's kind of a legal question. And since I'm not an attorney, I'm not able to answer that specifically. I think a survey would be the best option in that situation if there's not a category identified for the employees that you have on the work site.
All right, our last question here before we wrap up. What if I am performing as a sub and the prime neglected to inform me that the project had a Davis-Bacon requirement? What do I do when I find out?
Yeah. Really that would be unfortunate. So hopefully the subcontractor, you want to do your due diligence. You want to make sure that if you're bidding on a contract, you also review those documents, any attachments, and hopefully the prime would have notified you of that requirement. But again, really it does come back upon the subcontractor as well as the contractor. So I would suggest reaching out to Department of Labor and notifying them. Being transparent, being upfront about the situation. You will probably have to pay, some back wages to meet those requirements. But being forthcoming typically is going to lead to a better resolution than ignoring it or trying to hide the fact. I am aware of a company that wasn't my client, but was a Nebraska-based business that did reach out to Department of Labor. They did have to pay some additional wages, but they were not fined, they weren't debarred. They were forthcoming, and Department of Labor was really, in my estimation, really fair with them. And so I think that that would be the case in, hopefully in all cases, that if you're forthcoming and transparent, that, really you resolve the issue and you move forward. It can be a painful experience, but I think the more that you're, that the better you understand, first of all, probably the better the situation is going to be resolved. But the more forthcoming you are with Department of Labor, I think probably the better the situation is going to be.
Awesome. All right, I lied. We have one more. On a service industry like janitorial, if it is not listed as a separate category, we use general laborer. What are your comments on that?
Yeah. So with Service Contract Act, again, I would definitely, if you can get the right category, that is really preferred. And again, I would work with the contracting officer and Department of Labor to try to get a survey for the specific category. If not, I would hopefully try to get some indication of the category. Again, you want to make sure that you protect yourself as much as possible. But that would be again a separate. If you wanted to reach out to me, I'd be happy to maybe discuss further with that question as well.